The Supreme Court today heard a batch of appeals challenging the Karnataka High Court's verdict which upheld the ban on wearing of hijab by Muslim girl students in government schools and colleges in the state. The matter today was heard by a bench comprising Justices Hemant, Gupta and Sudhanshu, Dhulia. On the last date of hearing, the petitioners had sought for an adjournment of the hearing for 2 weeks, but the bench had declined such a request by stating that the court would not permit forum shopping and had accordingly issued notice to the state of Karnataka while posting the matter for hearing today. Let us now see what transpired in the courtroom and what were the arguments made today by the respective counsels. The first issue that the parties deliberated upon was whether wearing of the hijab is an essential religious practice in Islam. While deliberating upon this particular issue, senior advocate Rajiv Dhawan, representing the petitioner in this case at the outset of the hearing, argued that as per Article 145 Clause 3 of the Indian Constitution, a constitutional issue must be referred to the Constitution bench. He also stated that the case raises an important question as to whether hijab is essential to Islam or not. To this, Justice Gupta remarked that while wearing of the hijab may or may not be an essential religious practice, however, the issue in this case was whether the government could regulate the dress code prescribed. Senior Advocate Dhawan then proceeded to give instances of Supreme Court judges wearing tilak, pagris, etc. However, Justice Gupta interjected stating that pagri was a non-religious apparel and used to be worn in royal states. He further remarked, and I quote here, "My grandfather used to wear it while practicing law. Don't equate it with religion. Our preamble says ours is a secular country. In a secular country, you can say that a religious clothing has to be worn in a government-run institution." Senior Advocate Dhawan then brought to the notice of the court that while it had earlier been suggested that a scarf of the same color of uniform could be worn, students were nowadays being asked to remove scarves in the classrooms. He also highlighted that there were inconsistent High Court orders on this issue, as one order of the Kerala High Court stated that it was permitted and another by the Karnataka High Court stated that it was not. Senior Advocate Sanjay Hegre, also appearing for the petitioners today, argued on the issue as to whether the state government had the power under the Karnataka Education Act, that is the existing law, to prescribe the uniform. He contended that the crux of the issue was whether under section 133 subsection 2 of the Karnataka Education Act, it was mandatory for students to wear uniform as mandated by the governing body. While substantiating his argument, he asked the bench if an institution could debar someone from class for wearing a particular style of dress. He stated, and I quote here again, "Can the education of women be made contingent on not wearing a particular dress? Can you tell a girl, I'm sorry using a wrong phrase, a grown-up woman, that you will have no control over your own concept of modesty and say you cannot wear a chunni?" However, Justice Gupta retorted to this line of argumentation by highlighting that different public places require different dress codes. While giving instances of dress codes prescribed by golf courses and restaurants, Justice Gupta remarked, and I quote, "I remember the news a lady advocate came in jeans and it was objected to, saying you can't wear jeans. But technically, can the woman say you can't bar me for wearing a jeans? If you go to a golf course, there is a dress code. Can you say I can wear the dress I like there? In some restaurants, you have a formal dress code. In some, you have a casual dress code." Responding to this, Senior Advocate Hegre stated that everything must be seen in context and that in the present case, the context is that access to education is conditional to a vulnerable section of the society. He also highlighted examples of how Ishwar Chandra Vidyasagar, Fatima Sheikh and Savitri Phule had faced similar opposition when they were propagating for women's education. Furthering his arguments, Senior Advocate Hegre drew the attention of the court to section 39 of the Karnataka Education Act, For context, Section 39 prohibits any local authority or the governing council of any private education institution from denying admission to any citizen on the ground of religion, race, caste, language, indirectly or directly encouraging any propaganda or practice wounding the religious feelings of any class of citizens or insulting their religious belief in the education institution. He further highlighted that Section 133 of the Act states that the power of the state to give direction are subject to other provisions of the Act, and that the dress code was not among the category of subjects on which the government could make rules. He also referred to other provisions of the Act to contend that education institutions were required to inform parents about the change in uniform at least 1 year in advance, and that any uniform prescribed could not be changed after 5 years. He underscored that the government order stated that a person cannot wear a uniform showing their religion, and this has led to a substantial disadvantage to Muslim women. At this point, Justice Dhulia orally remarked that strictly speaking, hijab might not be a religious practice. The judge also differentiated between a chunni being allowed as part of the uniform compared to a hijab by highlighting that the chunni was worn on the shoulders. Additional Solicitor General K.M. Nataraj, appearing for the state of Karnataka today, stated during the hearing that the issue was very limited and pertained to the maintenance of discipline in school alone. To this, Justice Gupta asked, and I quote here, "How is the discipline of school violated if hijab is worn?" At this point, the Advocate General of Karnataka, Prabhuling Nawadgi, elaborated upon the state's stance by stating that after some students started protesting for hijab, another set of students wanted to wear the bagwa shawls. This led to a situation of unrest, and in this backdrop, the government order was issued on February 5th this year. When asked if hijab would be permitted in a minority institution, he stated that the state had left it to the minority institution's discretion. The bench also asked him what the stance of the government was regarding the government colleges in the state. In response, he stated that in Karnataka, there might be institutions of Islamic managements allowing the hijab, and that there is no government interference in this regard. With this, the bench decided today to continue the hearing next on Wednesday at 2 p.m. To provide a bit of context for our readers who are not aware of this issue, the Karnataka High Court on March 15 this year had upheld a Karnataka government order dated February 5th, effectively empowering college development committees of various government colleges in the state to ban the wearing of hijab by Muslim girl students in college campuses. The petitioners, who are Muslim girl students from various colleges in Karnataka, had approached the High Court after they were denied permission to attend classes on account of wearing the hijab. A full bench of the Karnataka High Court, comprising Chief Justice Rituraj Avasthi, Justice Krishna Dikshit and Justice J.M. Khazi, had held that wearing of hijab by women was not an essential religious practice of Islam. The bench had further held that the prescription of the uniform dress code in education institutions was not violative of the fundamental rights of the petitioners. These appeals filed before the Supreme Court argued that the right to wear a hijab comes under the ambit of the right to privacy under Article 21 of the Constitution of India and is protected under the fundamental right to freedom of speech and expression. Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.